Good morning, everybody, and welcome to our first webinar of the new financial year. Thank you for joining us today and taking the time to attend the webinar. Today we're going to be hearing from Kate Chalker in relation to some payroll tax issues. It's certainly an area that we're seeing the revenue officers in all of the states be a lot more active in recent times. And certainly some of the cases that have been run, which Kate will discuss, certainly are obviously more in the favour of the revenue officers. And in essence, if you have any clients who are operating with a contractor type model, no matter what type of industry, it's really something that should be reviewed and revisited. So in terms of some just general housekeeping, we have time for questions during the presentation, and at the end I'll be moderating the presentation today. So if you do have questions, if you just want to put them in via the chat function, and I can ask them at Kate an appropriate time, as I said, either during the presentation or at the end. The other aspect which you should be able to see is you'll be able to download today's presentation from the Files button, which should be on your screen. If you have any problems downloading that, just shoot me a message. Sometimes when we upload it, it doesn't upload properly, but we'll be able to fix that usually. At the end of the presentation today, we'll also be sending you a feedback email. We'd appreciate if you could complete the feedback in terms of that. It's a very short survey, but one of the questions that we ask is any particular topics that you would like, because most, if not all, of the topics that we present are based on requests from people who attend the webinars. I'd like to throw over to Kate. Before I do, I'll just introduce her. Kate's a senior solicitor based in Sydney here with me. She does, in terms of the work that she does with the firm, it's a bit of a mixture of everything, but she has a particular specialty and knack in relation to this sort of area in terms of revenue disputes, as well as also obviously payroll tax, hence her giving the presentation today. So I'm going to hand over to Kate.
All right, thank you, Adrian, and good morning, everyone. As Adrian mentioned, this webinar this morning will be looking at some recent developments in the world of payroll tax, particularly in relation to the use of independent contracting arrangements, and the ways in which in recent times both the courts, the tribunals and the commissioners of state revenue are trying to cast a much wider net in terms of the application of payroll tax and to subject a much wider range of situations to the relevant contract provisions. So just in terms of an agenda for this morning, firstly, I will take you through a brief overview of the payroll tax provisions and the contractor provisions as they exist under the relevant legislation. And then in terms of my first example, I'll be looking at the financial services industry and taking you through a practice note which was issued in New South Wales last year, looking at the application of payroll tax to that industry. Then I will walk you through the different exemptions which exist under the Payroll Tax Act, which can preclude different payments from being assessed for payroll tax. And then from there, I will turn my focus to the medical industry and run you through a couple of cases which have been handed down recently in the medical industry, which have been found in favour of the Commissioner to make those types of contracting or service arrangements subject to payroll tax. And then finally, I will make some predictions, if you will, as to the way in which the law is moving and give some recommendations moving forward as to what, if anything, your clients can do to protect themselves from a hefty payroll tax assessment. So firstly, just a brief overview of how the payroll tax provisions operate. So obviously, payroll tax is a state-based tax, which is imposed on all taxable wages which are paid by an employer to an employee. And the way in which it works is that an employer is required to register with the relevant Office of State Revenue if the total wages that they've paid throughout the year exceed the annual threshold. And obviously, we've got a wide range of people attending the webinar today from all different states throughout Australia. So I've put here just a little table setting out what the annual threshold is and what the tax rate is for Queensland, Victoria, New South Wales, and Western Australia. You'll note that Victoria in particular has a very low threshold compared to the other states. So they're really trying to get a lot of different payments within their system down there in Victoria. In New South Wales, we do have a fairly high rate, which has recently been increased on the 1st of July. So the lower rate that was introduced for COVID is no more. And so the payroll tax rate has been increased to 5.45% here in New South Wales. And so obviously payroll tax is intended to apply to your standard employment situations. So where you have an employer that is making regular salary or wage payments to an employee, where the total payments exceed the threshold, those payments will naturally be subject to payroll tax. But the Commissioners of State Revenue have looked to expand the application of payroll tax by introducing two other sets of provisions, and they would be the employment agency provisions and the contracting provisions. And in today's webinar, I will be focusing on the latter of those, the contracting provisions, because that's where we've had the most recent development in that area. So payroll tax is governed by the Payroll Tax Act. And on this slide, I have set out the references to the New South Wales Act. But for those of you that do operate in different states, you should know that the provisions are very much similar. The sections might actually be the same for you because the legislation has been harmonised throughout Australia since 2009. So I do have the New South Wales references here, but your references will be largely similar as well. So in New South Wales, the contractor provisions exist under Division 7 of Part 3 of the Act. And the way in which the provisions operate is that, firstly, you need to have a relevant contract in order for payroll tax to be imposed. And there is a very broad definition given of a relevant contract under Section 32 of the Act. And so it is defined to be a contract, agreement, arrangement, or undertaking under which a contractor provides an employer with the services of a worker. So that's the first requirement, in that you need a relevant contract. And from there, then we have what I call the deeming provisions, because these provisions talk about employer and employee, which normally you wouldn't have within a contracting arrangement. You would have a principal and an agent. But for the purposes of this section, under Section 34, it's stated that an independent contractor that is providing those services will be deemed to be an employee for the contractor provisions. And on the flip side, the person or the entity that is receiving the services from the contractor will be deemed to be an employer. And then following on from there, we have Section 35, which is how the payroll tax is actually imposed. So that section provides that if there are payments made by the deemed employer to the deemed employee that relate to the performance of work under the relevant contract, those payments will be deemed to be wages, and payroll tax can be assessed on those wages. I've got there unless an exemption applies, and I'll come back to those exemptions a bit later in the webinar. So as you can see, the definition of relevant contract is quite vague and quite open to interpretation. So that's why we need to then look at some external materials, such as documentation produced by the Office of State Revenue or any relevant cases. So that's why I'm going to take you through, firstly, the practice note in relation to the financial services industry. So this practice note came out in February last year, and it was really designed to explain how the payroll tax provisions and the contractor provisions apply in the financial services and the credit services world. So some of you may be familiar with how the financial services industry operates, but I will just run through it in case some of you are not aware how it generally operates. So the financial services industry is quite highly regulated, and the person or entity that is carrying on the business of providing financial services is required to hold a valid license, which has been issued under the Corporations Act. And I understand that it can be quite an onerous process to both obtain that license and to maintain it throughout the course of running that business. So the way that it often works in practice is that the person or entity that holds the license will then appoint other people to use that license to carry on their own business of providing financial services. So the licensee, being the person or entity holding the license, will appoint what's called an authorised representative as its agent to then provide the financial services on its behalf. And often people providing financial services recognise that there's a risk there, so they would prefer to trade out of a company, for example, rather than as a sole trader. So in that situation, the licensee could appoint the company that the person is trading out of as its authorised representative, and then that company can then sub-authorise the individuals who are actually providing those financial services. So in case you're more of a visual person, this is an example taken from the practice note itself. So just to explain how it works, we have ABC Limited up the top. That is the company that is carrying on the financial services business, and it holds the valid license under the Corporations Act. ABC Limited has then appointed Joe, down the bottom in red, as the authorised representative. So that means that Joe can use the AFS license of ABC Limited to perform financial services to its own clients. And in terms of the remuneration to Joe, that would often take one of two forms. So it could either be an upfront commission or a trail commission. So the upfront commission is fairly self-explanatory. That would be paid by ABC Limited to Joe immediately on the sale of a financial product, or else Joe could receive a trail commission, which would be paid to him on the anniversary of the sale of the financial product, as long as that contract is still in place. The practice note also looks at the credit services industry, which is largely the same. However, some of the terminology is a bit different, and the act that governs the industry is also different. So a business which engages in credit activities has to hold a license under the National Consumer Credit Protection Act. And rather than an authorised representative, you have what's called an authorised credit representative, an ACR, or you would have a sub-authorised credit representative, an SCR, where you have that company interposed in the middle. But for you and I, we would refer to those ACRs and SCRs as mortgage brokers. So again, just another diagram to explain how that would work. So up the top, we have Bank North, a company which holds a valid license under the Act. It would then appoint Northern Star, another company, as its authorised credit representative. And from there, that company could then appoint the three individual mortgage brokers as the sub-authorised credit representatives. So the mortgage brokers could then go out and provide those credit services using the AC license of Bank North. And so for some time now, people have looked at these licensing arrangements and considered them to be safe from payroll tax, because the argument that has been run is that the three men down the bottom who are providing the credit services, they're providing those services to their own clients. They're not actually providing any services to Bank North, the licensee. So people had accepted that there was no relevant contract in place between the licensee and the agents, and therefore the payments made in the form of a commission should not be subject to payroll tax. However, in the recent practice note, which was issued by the Commissioner has dismissed that argument and said that these arrangements are unfortunately relevant contracts for the purposes of payroll tax. So those different arguments have been described as common misconceptions from the point of view of the Commissioner. So I'll take you through what the different arguments were that were raised and subsequently rejected by the Commissioner. So firstly, people have argued that the agents, as I said, do not provide any services to the licensee. Rather, they're providing services to their own clients. The agent is able to take the clients with them if they decided to terminate the licensing arrangement with the licensee. The agent is responsible for finding their own clients. The licensee doesn't provide any leads to new clients. And that the licensee simply allows the agent to tick off the regulatory framework to be able to conduct their own business of providing financial services. There were some other arguments raised, being that looking at the relationship, it's really more of a franchise arrangement rather than one of a relevant contract. It was also argued that any payments made by the licensee to the agent is really just returning the money that the agents had already earned in carrying on their own business. Also raised was the point that normally the agent is not required to operate from the licensee's premises. They can operate elsewhere. And finally, that looking at the commercial relationship as a whole, it doesn't fit within the definition in the contractor provisions. But as I mentioned, unfortunately, the Commissioner looked at each of these different arguments and said that none of them were valid. And so the Commissioner has provided some general comments on the application of the relevant contract provisions to the financial services industry. So the Commissioner in that practice note found that these types of scenarios do give rise to a relevant contract and that they do meet the definition in Section 32 of the Act. And the Commissioner noted that even though the agents are providing services to their own clients, that those clients are also clients of the licensee, and that shouldn't prevent the application of the provisions. And finally, it also doesn't matter that the licensee is providing services to the agent in terms of providing that license for them to use, because the Commissioner said that that's a normal feature of a relevant contract. So if we take those comments made in the practice note and refer back to the legislation, what does that mean? It means that there would be a relevant contract between the licensee and the agent under Section 32. It then means that the licensee would be deemed to be an employer under Section 34, and conversely, that the agent would be deemed to be an employee. And so therefore, under Section 35, if the licensee is making payments to the agent which exceed that threshold, then those payments will be deemed to be wages and payroll tax will be assessed on those amounts. Of course, unless the licensee is able to point to an exemption under the Payroll Tax Act. So under the Payroll Tax Act, there are a total of 7 different exemptions which can apply in different situations. However, there are 3 which are most likely to apply and which we see pop up more often than not. And so the first one is where the practitioner provides services to the public generally. So in this kind of situation, it wouldn't be sufficient just to have the one licensing arrangement with the one licensee, because that would really be seen as one source of income. So the agent would need to find some other way to provide services to the public generally, and to derive their income from other sources. The second exemption, which I've put on this slide, is where the practitioner performs work for no more than 90 days in a financial year. And that one is as it reads. However, important to remember that if the contractor is only working for 1 hour on a particular day, for the purposes of the legislation, they will be deemed to have worked 1 whole day. So that's definitely something to keep in mind when calculating the amount of days worked. And finally, payments will be exempt where the services provided by the practitioner are performed by 2 or more persons. So, for example, if you had a company acting as the contractor, and then you had 2 or more employees or 2 or more contractors of that company providing the services under the agreement, then you would be able to rely on that exemption under the Act. However, if certainly in the financial services industry, and as I'll come to the medical industry, if it's not possible to point to any of those exemptions and to produce the relevant evidence that they apply, then it's looking more and more likely that these types of professional services arrangements and contracting arrangements will be subject to payroll tax, which will mean in New South Wales, for example, an additional 5.45% tax on those payments. So as I mentioned, the next area that I wanted to focus on was the medical industry and a couple of recent cases which have been handed down looking at the application of the relevant contracts provisions. So I'm sure that many of you have clients who are doctors or who are medical practices, and you would have seen many a service agreement. So often the way in which it will work is that the medical practice will enter into a separate service agreement with each of the doctors that work within their practice. And under the terms of that agreement, the medical practitioner would be responsible for providing medical services to their patients. In terms of the medical practice, they would be responsible for providing a room for the doctors, for providing various facilities, and also a variety of administrative services. And then often in the medical industry, the doctors will direct their patients to pay the medical practice directly rather than paying the doctors themselves. And so the practice would be responsible for looking after the bulk billing and any Medicare claims. And then at the end of a period, normally a month, the medical practice would deduct their service fee, which might be somewhere around the 30% mark of the revenue brought in. So they will keep that percentage, and then the balance they would pay to the doctor or the entity that they're trading out of. So that's the way in which a service agreement would normally operate within the medical industry. And for quite some time, it was the generally accepted position that if you had a well-drafted service agreement between the medical practice and the different doctors, that those types of payments would not attract payroll tax, because a similar argument was relied upon to say that the doctors are providing medical services to their own patients. The doctors are not actually providing any services to the medical practice itself. Therefore, we don't have a relevant contract, and those payments made, the 70% payment at the end of a period to the doctor, should not be subject to payroll tax because the requirements haven't been met. So that was the previous position, but with the release of a couple of recent judgments, there's been a large question mark placed over that position. So the first case that I want to take you through is a Victorian case, which you may have heard of, called Optical Superstore. And so the facts of that case were as follows. We had the Optical Superstore Proprietary Limited acting as trustee for, I believe there were 4 different trusts. And each of those trusts were carrying on an optical dispensary business throughout Victoria, known as the Optical Superstore, a bit like an OPSM, if you will. And then the company would then enter into what they called an Optom tenancy agreement with each of the optometrists that worked within their stores. And under that tenancy agreement, the Optical Superstore was required to provide a room to the optometrists. The optometrists would then provide optometry services to their patients. So that would be conducting eye tests and prescribing different lenses. And then in terms of payment back to the Optical Superstore, the optometrists were required to pay an occupancy fee at the end of each month. It was a little bit peculiar in the way in which that amount was calculated. Rather than taking a percentage of the revenue, the optometrists actually had to put down how many hours they had worked in the period, and so they were remunerated on an hourly basis. So this is just a diagram explaining the arrangement that the Optical Superstore had in place with the different optometrists. So on the left-hand side, we have the Optical Superstore. It was acting as the landlord under the agreement. And then at the top of the right-hand side, we had the tenant, which would be either the optometrists themselves or the related entity that they were trading out of. And so that optometrist would provide the optometry services to their patients. And then in terms of payment, from 1992 to about 1997, the tenant would then pay the occupancy fee back to the landlord at the end of each month, using that calculation that I mentioned. From about 1997, there was a slight variation to the way in which this arrangement worked, because the Optical Superstore recognised that there was a potential risk that they might not get paid that occupancy fee. So rather than having the patients pay the optometrist directly, it was a requirement that the patients pay the Optical Superstore. And then at the end of each period, it was up to the Optical Superstore to work out the occupancy fee, to keep that, and then to return the balance to the optometrist. So that's how the arrangement worked. And so the Victorian Commissioner of State Revenue had a look at this arrangement and thought, this doesn't look like a tenancy arrangement to me. This looks like the type of arrangement which could be a relevant contract and which should be subject to payroll tax. So there was an assessment issued to the Optical Superstore, and an objection process followed. So the Optical Superstore objected on the basis that there was no relevant contract, because in this situation, the optometrists were providing services to their own patients. They were not providing any services to the Optical Superstore itself. And so there could not be a relevant contract, and there shouldn't be an assessment for payroll tax. Unfortunately, the Commissioner disallowed that objection, and so the company sought a review of that decision in the Victorian Civil and Administrative Tribunal. And that decision was handed down in February 2018. And unfortunately, in this situation, the tribunal member found that there was, in fact, a relevant contract, so found in favour of the Commissioner. So the member considered the argument made by the taxpayer in that the optometrists weren't providing any services to the Optical Superstore, but actually disagreed with that point of view. What the tribunal member found was that by providing those optometry services, by conducting those eye tests and prescribing those lenses, what that meant was that those patients would then go back into the store and purchase frames, purchase lenses, purchase cleaning cloths for their glasses, which would then mean a financial benefit for the Optical Superstore. So Member Tang, in this case, found that there was a benefit derived by the Optical Superstore as a result of the optometrists providing services to their patients. I'll read you this quote, which comes from paragraph 85 of the judgment, which says that the arrangements were put in place to benefit the Optical Superstore because the provision of optometry services on site would lead to increased sales of frames, lenses, and other optometry products. And that looking at the wording of the legislation, there was no incongruity in finding that the services of the optometrist were provided to the Optical Superstore as well as to the patients. So as you can see, there was a much broader interpretation of the relevant contracts provisions given in this case. So whilst there was found to be a relevant contract between the Optical Superstore and the different optometrists, there was a second argument which was raised by the taxpayer. And that argument was that the amounts should not be deemed to be wages because the amounts were actually held on express trust for the optometrist. I'll just remind you of what Section 35 says. It says that the payments must be for or in relation to the performance of services under the relevant contract. And the tribunal agreed with that argument by the taxpayer to say that when the payments were made directly by the patients to the Optical Superstore, they were held on express trust, and therefore it didn't meet the requirements of Section 35, and they couldn't be wages for the purposes of the contractor provisions. So that actually turned out to be a win for the taxpayer, because even though there was found to be a relevant contract, the commissioner wasn't able to assess those payments for payroll tax because they weren't able to be deemed wages. So, of course, the commissioner wasn't happy with that outcome because he lost in terms of Section 35. So the commissioner decided to appeal that decision, that second point, to the Victorian Supreme Court. And that judgment came out in September 2018. And in this case, the Supreme Court upheld the decision of the tribunal and found that the amounts paid by the Optical Superstore to the optometrists were not paid or payable for or in relation to the performance of work. In other words, they didn't meet Section 35 and they couldn't be deemed to be wages. Justice Croft of the Supreme Court found that the meaning of payment under that section does not extend to a return of money by one person to another where the money already belongs to that second person. So that was another win for the taxpayer. And so the commissioner decided to have one final crack. And so he again appealed that decision on Section 35 to the Victorian Court of Appeal. And that judgment was released a year later in September 2019. And in that judgment, the Court of Appeal overturned the Supreme Court's decision in relation to Section 35. And the Court of Appeal found that the amounts were, in fact, paid or payable in accordance with Section 35 of the Payroll Tax Act. So what the court found was that the ordinary meaning of payment within that section does readily embrace a payment of money to a person who is beneficially entitled to that money. So that was the end of that litigation process. Ultimately, that was a win for the commissioner because the courts found that there was a relevant contract where previously people would have thought that there was not because there was not that provision of services to the Optical Superstore. And then it was also a win because the express trust argument wasn't upheld by the Court of Appeal. So the outcome of that case was that the payroll tax assessments were upheld. And unfortunately, the Optical Superstore was required to pay that payroll tax on the wages paid to the optometrists. And that position has continued and has been reflected in a more recent New South Wales decision. And that decision was Thomas and Nas. So again, I'll run through the facts of that case briefly. So this was a medical practice. So Thomas and Nas Proprietary Limited was carrying on a business of running 3 medical centres throughout New South Wales. And as is normal practice, they would enter into a service agreement with each of the medical practitioners that worked within their medical centres. And it was a fairly standard service agreement in some ways, in that the doctors were responsible for providing the medical services to patients. The medical centre itself was required to provide a room for the doctors and also to provide different administrative services to allow the doctors to provide those services. And in terms of billing, all but 3 of the doctors in this case directed that the patients go through bulk billing. So in this case, it was up to Thomas and Nars to manage the bulk billing process, to manage any Medicare claims. And finally, at the end of each month, we had a service fee of 30%, which was to be retained by the medical practice, and the remaining 70% would be paid to the doctor. So that part of the agreement was fairly standard. However, there were some features of the agreement which perhaps weren't drafted so well and which we ordinarily would not recommend be included, because they did tend more towards an employment relationship than one of principal and agent. So some of those features which the Commissioner picked up on were as follows. So the doctors under the agreement were required to meet roster commitments. They also had to abide by the different protocols of the practice. And there was also a leave policy in place with the medical practice. In addition, there was a minimum rate per hour to be charged in the first 3 months of engagement. This is a particularly strange one, that the doctors were required to promote this one individual medical centre. And again, there was a restraint of trade under the agreement of up to 5 kilometres for up to 2 years after a doctor leaving that clinic. So looking at those features, they're not great, certainly from a contracting perspective, as they do suggest that the doctors have to be loyal to this one practice, which is not what you want from a contracting perspective. So, of course, the Commissioner looked at these features and decided that there was a relevant contract in the Commissioner's eyes. And so the Commissioner assessed Thomas and Nars for payroll tax on the amounts which were paid to the medical practitioners. And much like the last case, there was an objection process. Thomas and Nars objected to that assessment using the argument which I raised before, which is that the doctors are providing services to their own patients. The doctors are not providing services to the medical practice itself. And so there shouldn't be a relevant contract, and it should attract no payroll tax. But unfortunately, the Commissioner disallowed that objection. And so again, the taxpayer sought a review of that decision in the tribunal. So first we went to the New South Wales Civil and Administrative Tribunal, and that decision came out in September of last year. And the tribunal in this case found in favour of the Commissioner to say that there was a relevant contract in place. So the tribunal member again considered the argument that there was not that provision of services to the medical practice and disagreed. The logic that they applied in this case was that Thomas and Nars was in the business of conducting a medical practice, and that a medical practice can't do what it does without the use of doctors, without having those doctors in the clinic able to provide those services to patients. So by the doctors providing those services to patients, what they were doing was actually allowing Thomas and Nars to continue trading and to continue running their business. So even though there wasn't that direct provision of services to the medical practice, it was found that Thomas and Nas did derive a broader benefit from the arrangement and that there was a relevant contract in place. I'll also take you through this quote here from paragraph 39 of the judgment. So this came from Member Goodman, where he said that the agreement secured the provision of the services provided by the doctors to the patients of the applicant's medical centres, and that the services were a necessary part of the applicant's medical centre business, and that the doctor provided the services not only to their own patients, but also to the applicant, Thomas and Nas. So again, we see a very broad application of the relevant contract provisions, which previously would not have been thought to occur. Now, this case was appealed by the taxpayer, and that appeal decision actually came out just a couple of weeks ago on the 6th of July. So Thomas and Nas appealed the decision of the tribunal to the appeal panel, and Thomas and Nas tried to raise 7 different grounds of appeal. Unfortunately, none of them got up for the taxpayer, and so the appeal was dismissed, and the grounds were rejected for one of 3 reasons. Firstly, the taxpayer was found by the tribunal to be raising questions of fact rather than law, and the way in which it works is that the appeal panel can only hear questions of law. It can't go back and challenge any findings of fact by the previous tribunal. Also, Thomas and Nas tried to raise a new argument which was not previously raised in the objection stage or the previous tribunal proceedings. They tried to rely on a new exemption to say that the services that they provided were not of a kind ordinarily required by the medical centre, and that they were performed by people who ordinarily provide those services to the public generally. So that was a new exemption. The appeal panel considered whether they should even consider the application of it because it was not previously raised, and the taxpayer had the opportunity to bring up that exemption in the earlier proceedings. But in any event, the appeal panel found that that exemption did not apply. And finally, Thomas and Nas tried to raise a ground to say that the tribunal should have followed a particular judgment called Homefront Nursing, which found that payroll tax was not applicable because Section 35 was not met. And so Thomas and Nas tried to argue that the tribunal erred in not following that judgment. But unfortunately, that didn't work for the taxpayer because the tribunal stated that they're not bound by the doctrine of precedent. And because the decision in question was not a decision of the appeal panel, the president, or the deputy president, they weren't required to follow that same reasoning. So that appeal has now been heard and unfortunately went in favour of the commissioner. So those payroll tax assessments have been upheld, and unless Thomas and Nas is able to appeal to the Supreme Court, they will be required to pay the payroll tax on the wages paid to the doctors. Now, I understand that the New South Wales Commissioner of State Revenue has prepared a new practice note, similar to the one which he prepared in the financial services industry. And I also understand that he was waiting for this recent appeal to be finalised before issuing that practice note. So because that decision has gone in favour of the Commissioner, it probably won't take very long for that practice note to be released. But that practice note is very likely going to say that these types of service entity arrangements between doctors and medical centres are relevant contracts, and that unless they are able to point to a relevant exemption, that payroll tax will be applied. Unless the medical practice is able to point to an exemption, or unless they do fall below the relevant threshold. So yes, these cases have really shown that the courts are taking a much broader view of the relevant contract provisions, and it's no longer sufficient anymore just to have a well-drafted service agreement, because the commissioner will likely find a relevant contract, and payroll tax will be assessed that way. It will be interesting to see whether there is a bit of backlash to the issue of that practice note from the medical industry, because the way I see it is that if all of these types of arrangements will be subject to payroll tax, that will mean an added cost for the medical centres. And it's quite possible, quite likely, that these medical centres won't want to bear that cost on their own. They'll look to recoup that additional tax by increasing the cost of their healthcare, which in turn will make healthcare more expensive, more unaffordable for the general population. And given that healthcare is such an essential service, it might be that the medical associations get involved and try to dispute the issue of this practice note. So it will be interesting to see whether there's any action on their behalf. But just in summary, I think you can see from the practice notes and the recent cases that the Commissioners of State Revenue are taking a much more aggressive approach in terms of the application of payroll tax. And as I said previously, where you would have a well-drafted contracting agreement or a service agreement, and you could feel quite confident that no payroll tax would apply, that's no longer the case. It's more and more important now that you look to see whether any of the exemptions are applicable. And if you think that they are, making sure that you're keeping all of the relevant paperwork that would be needed to produce to the Commissioner in the event of an audit or a review. But yes, certainly financial services industry, medical industry, and other professional services definitely need to be on the lookout for payroll tax issues. So Adrian, do we have any questions?
Yes, Kate, we've got one that was submitted before the presentation, so I'll just read it out for the benefit of everybody. If the clinic and the practitioner sign a service agreement that the clinic collect the service fee and deposit it to the trust account, and say every fortnightly transfer the entire fees collected to the practitioner, and at the same time issue a service invoice which includes room lease, marketing expenses, administration, fee collecting and disbursement, etc., will such an arrangement be acceptable and resolve the issue?
Look, I think it would certainly help if the payments are being held in a separate trust account rather than having them paid out of the same account that's paying the medical receptionist, for example. But I can't 100% guarantee that that would avoid the application of payroll tax, because particularly if we look back to the Optical Superstore case, that's where the argument of express trust was raised. And unfortunately, the Supreme Court rejected that argument and said, even though there was an express trust for the optometrists, it nonetheless met the requirements of Section 35, and they were able to deem those amounts to be wages. So yes, I think hopefully we get some clarification in the practice note whether that would circumvent a payroll tax assessment, but I don't think that it could be that simple, unfortunately.
Okay, and just one more at this stage. With a medical practitioner, it is their provider number upon which the medical service is provided. Legally, then, they are the income earner, at least from Medicare's perspective. The practice operating merely collects the income from Medicare and patients on behalf of the practitioner. In this case, the government is saying payroll tax applies. Note the practice is not legally able to charge for services. Same for real estate agents.
Sorry, I'm just trying to understand the question a bit better.
I think in essence it's that because it's the doctor that has the Medicare number, they're the one that is in effect getting paid. I guess if all you were charging was the Medicare amount, you might be able to have an argument there, but obviously in most circumstances, well, it's very rare these days to have bulk billing doctors, but there'll be other fees as well.
Yeah, there was the case that I referred to earlier of home front nursing. That was where it was argued that this type of arrangement was just a collection mechanism of the Medicare fees, and that was found in favour of the taxpayer. But that was the case that the tribunal in Thomas and Nas wasn't able to follow. So, yeah, we do have a bit of a conflicting view there.
And in terms of that other point, in terms of real estate agents, in reality, it's going to apply to any model that has, in effect, a contractor or an agent model, whether that's real estate agents, physios, influencers, models. We've seen a recent actors matter and actors and models called Bonner, involving Bella Model Agency. So really, it's any of that sort of contractor type model. Another question, Kate: are the decisions in New South Wales able to be relied on in other states?
I think they would be. Yeah, they could definitely give reference to those cases in other states because, like you mentioned, the law is very much harmonised throughout Australia. So I think that the decisions that we're seeing in New South Wales and Victoria will very much apply in the other states throughout Australia.
Just a couple of follow-ups to that earlier question in terms of the person that submitted it saying that they work for a medical practice where they don't have a provider number, so they can't bill the patients. Again, it's going to come back down to what actually is the service and what's the relevant contract from a payroll tax provision. Just because you don't have the provider number doesn't mean it may not be subject to payroll tax. I'll just do a little bit of admin just while we wait to see if there's any further questions that come through. As I mentioned, you will be receiving a feedback email at the end of this presentation. If you could complete it, it'd be much appreciated. It's only 4 questions on it. With that, you can do 1 or all 4, but it's obviously well appreciated. Our next webinar will be, and also in the feedback email, you can also download the slides again if you haven't had a chance to do that. Our next webinar will be at the end of next month, which will be on getting a business ready for sale, and Kim Barnes, based out of our Brisbane office, will be presenting that. Just one further question for you, Kate. Why would an interstate precedent work when they're not bound to follow a local precedent?
Yeah, I think that was a specific tribunal question in that the tribunal appeal panel wasn't required to follow the precedent. But certainly if it went to the Supreme Court, for example, they would be required to follow other precedent.
Yeah, from a strict legal perspective, other courts in other states are required to follow decisions in the other states of, in effect, an equivalent level, but not tribunal. So as Kate said, Supreme Court or something like that, they have to follow those decisions unless there's a reason not to. All right, we're going to close it off there. Thanks everybody for your attendance today. Look forward to seeing you again at the next webinar. This webinar will be on our YouTube channel sometime either today or early next week. But you also should receive an email from the Webinar Jam system with a link to the recording as well. So thanks again, and hopefully see you at the next one. Thanks, Kate, for presenting today.
Thank you.